Ohio versus Justin Dan, case number 25 CR 1480. Defendant is present and represented by defense counsel Rachel Smith. Defendant has previously pled guilty to burglary, a felony of the 3rd degree, and possession of cocaine, a felony of the 5th degree with the forfeiture specification. Since then, a pre-sentence report and drug and alcohol evaluation, as well as an opportunity for a victim impact statement has taken place. We're here today for the sentencing.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. On behalf of Mr. Dam, we are asking the court to impose a period of community control. Your Honor, Mr. Dam has an extensive history, but from the beginning of this case, he's indicated that at this point in his life, he is trying genuinely to change in a manner that he has not in the past. Your Honor, prior to the instant offense, Mr. Dam had been released from prison back in May, had maintained 5 months of sobriety, was employed. He then lost his housing, ended up relapsing, and then committed the acts that bring us to court here today. Mr. Dam understands that his criminal conduct is a direct result of his drug use and that he needs to address both. Mr. Dam has never been on probation as an adult, and he's 29 years old. He's single, he has no kids. He's asking the court, despite how things look on paper, to give him one opportunity as an adult on community control so that he can pursue a treatment path and address the myriad of issues that bring him in front of this court today.
Thank you. Mr. Dam, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Yes, sir.
Good.
I know I've been in front of you multiple times, and I can't sit here and act like I didn't do what I did, because I did, and I'm trying to take full accountability of it. As I've gotten older, been to prison, I haven't learned anything from there. I just want a chance to do what's right for myself. My head space is different this time because I actually want it. I've actually been trying to put the work into doing it. Even though I did slip up and do what I did, I regret it. I tell my mom every day how much I regret doing what I did. I don't want to be here in front of you right now and saying what I'm saying, but I'm taking accountability for it, and I just want the chance to try to do the right things and prove to people that I can do the right things. Since I got bonded out a couple months ago, I've done everything my attorney has asked for, everything the court has asked for. Clean urines, going to all of my appointments, keeping in contact with everybody I'm supposed to. And I want to do the right thing. I don't want to keep coming in front of you. I don't want to ever come in front of you again. I don't want to be in this situation ever again. And I'm tired of it. And I just want to do the right thing. And prison isn't helping me. And I know that I don't need to commit a crime to get help. But I'm just asking you to please just give me this chance. And if I fuck up, or if I mess up, I'm sorry. If I mess up, then I know what happens. I just really want this chance. And I please hope you can consider that.
Thank you.
And sorry for my language.
Ms. Smith, anything else?
Not at this time, Your Honor.
All right. On behalf of the state, Mr. Gretzky.
Your Honor, the state recommends prison. In this case, the facts have been outlined, and change of plea hearing are also in the pre-sentence report. The victim, the defendant's father, is the victim of this, or stepfather, excuse me, is the victim in this case. State feels prison is appropriate because of the defendant's exceptionally long criminal history. For that, a long history of juvenile adjudications where there were failures to rehabilitate, and then his history, criminal history, at least with felonies as an adult, started with a burglary conviction for which he went to prison for in 2017. It was a theft conviction for which he also went to prison for in 2017. Shortly after he was released, he was convicted or committed another burglary. He was convicted and went to prison for that offense in 2021. Shortly after being placed on parole and being released from prison in that case, he committed another felony offense of attempted robbery and disrupting public service. He was sentenced to prison in that case in 2023. Then he was released in that case in May of 2025. The defendant committed 2 misdemeanor crimes before committing this one. He was out on bail, at least in one case when this offense was committed. The defendant has not responded favorably to any of those prison sentences, but additionally he hasn't responded favorably to the community control sanctions that were placed on him in the municipal court for those misdemeanors, which he's received convictions for as well. There is a pattern of alcohol use related to this offense. The defendant has not, despite court orders, it's my understanding, again from municipal court, followed.
Ohio versus Justin Dan, case number 25 CR 1480. Defendant Justin Dan is present with his defense counsel. He has previously pleaded guilty to burglary and possession of cocaine. A pre-sentence report and substance abuse evaluation have been completed, and the court is now proceeding to sentencing. Defense counsel requests community control, stating the defendant has a long history but is genuinely trying to change. After being released from prison earlier this year, he stayed sober for several months and was employed, but later relapsed after losing housing, leading to the current offense. Counsel argues this is his first adult probation opportunity and asks for treatment instead of prison. The defendant personally addresses the court, admitting his past crimes and taking responsibility. He expresses regret, says he has been trying to improve, staying compliant since release, attending appointments, and remaining drug-free. He asks for one last chance at community control to rebuild his life. However, the state strongly opposes, highlighting an extensive criminal history starting from juvenile years, repeated burglary and theft convictions, multiple prison terms, and repeated reoffending shortly after release. They argue he has failed previous chances, failed probation, and has not shown sustained rehabilitation. The state recommends prison. After considering the record, the court finds the defendant is not suitable for community control due to repeated offenses and high risk of reoffending. The court sentences him to 24 months in prison on count 1 and 8 months on count 2, to run concurrently, with credit for time served.
Recidivism is more likely. There's nothing indicating it's less likely. In 29-13B1, defendants previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's just no way this court can make a finding defendants amenable to available community control sanctions. Therefore, it's the sentence of this court that on count 1, defendant served a term in prison of 24 months. On count 2, he served a term in prison of 8 months. Those will be served concurrent with each other for a 24-month prison term. He has credit for 4 days that he served on this case. Any other time that was in the jail, he was serving his sentence for the misdemeanor offenses that he was convicted of.